Welcome to this interview practice session, where today we'll take a look at some questions and model answers focused on the data management competency. And this competency falls under the RICS mandatory competencies and is applicable to all pathways. And the following questions and model answers are really designed to cover this area in detail to help candidates feel better prepared for their final assessment interview. So without further ado, let's go straight into the Q&A practice. And the first question we'll take a look at is, what are the benefits of cloud-based storage systems? And to address this question, we could firstly say that information is backed up securely on encrypted servers, and accessibility of information can be managed via online settings seamlessly between each member of the team, and cloud systems are often cheaper than the cost of physically storing and managing files, and it's also convenient to send and share files online instead of mailing physical copies. Cloud systems are more environmentally friendly, and multiple users can access the same documentation. Documents and folder systems can also be synchronized, allowing multiple people to work on the same documents seamlessly. The next question we'll take a look at is testing our understanding of the term non-disclosure agreement. And to address this, we can say that non-disclosure agreements are used to protect against the disclosure or sharing of any confidential data. Prior to the confidential data being shared with the recipient, clients will typically request that the recipient signs up to an NDA or non-disclosure agreement. They're often used when confidential, sensitive, innovative, or intellectual property information is being shared to prevent this information being used by competitors. The next question we'll take a look at again centres around confidentiality of client data, and this is, if two separate departments within your firm were working for two rival companies, how would you ensure that client-sensitive data was managed? And to address this, we can firstly say that we would make the client aware of the risks associated and how this was proposed to be managed within the firm to ensure that they were happy with this. We would make them aware and check their understanding of the conflict of interest. We would also need to seek a letter of instruction to continue before continuing to act on their behalf. Some of the procedures we could put in place to negate any sensitive information being shared between the teams would include exclusivity of staff, the use of non-disclosure agreements, single communication lines going back into the client, separate working locations between both teams, and the use of secure document storage systems. The next question we'll take a look at is checking our understanding of the key persons outlined within GDPR. And firstly, we would need to reference the controller. And the controller is a natural person or legal entity that determines the purposes and means of processing of personal data. For example, when processing an employee's personal data, the employer is considered to be the controller of the information. We could also make reference to the processor, and this is the natural person or legal entity that processes personal data on behalf of the controller. For example, a call centre acting on behalf of its client would be considered to be a processor. We could also make reference to the DPO, or Data Protection Officer, and the Data Protection Officer is a leadership role required by EU under GDPR, and this role exists within companies that process the personal data of EU citizens. The DPO is responsible for overseeing the data protection approach, strategy, and its implementation. The next question we'll take a look at is, what are the 8 individual rights under GDPR? And these include firstly the right to be informed, where all organisations must be completely transparent in how they are using personal data. The right of access, where individuals will have the right to know exactly what information is held about them and how it is being processed. The right to rectification, and the right to erasure, which is also known as the right to be forgotten, and this refers to an individual's rights to have their personal data deleted or removed without the need for a specific reason. The right to restrict processing, the right to data portability, which allows individuals to retain and reuse their personal data for their own purpose, the right to object, and the right of automated decision making and profiling. And finally, we may also be asked a question on our understanding on the procedures that companies can put in place in order to achieve GDPR compliance. And to address this, we could first of all say that we would raise awareness across the business, we would audit all personal data, update our privacy notice, review procedures supporting individuals' rights, identify and document companies' legal basis for processing personal data under GDPR. We'd also need to review how we seek, obtain and record consent. How is data managed and protected within your firm? And to address this, we could reference a number of factors such as secure document storage, backup of documentation, secure processes for the sharing of any confidential information, a set of common data standards, the formatting and standardization of reports, processes for data sharing with internal and external teams, and processes for managing any paper forms and digital forms of information. A follow-on question we may be asked is, what is GDPR? And to address this, we can say that the General Data Protection Regulations is a regulation in EU law on data protection and privacy. And this applies in the European Union and the European Economic Area. It also addresses the transfer of personal data outside the EU and associated areas. Another follow-on question we may be asked in relation to this area is, what does it mean to be GDPR compliant? And to address this, we can say that GDPR is a regulation that requires businesses to protect the personal data and privacy of EU citizens for transactions that occur within EU member states. We may also be asked a question on the 7 principles of GDPR. And to address this, we can say that this includes lawfulness, fairness and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. And staying with the topic of GDPR, we may also be asked a question on what processes or things must companies put in place to ensure GDPR compliance. And to address this, we could make reference to raising awareness across the business. We could also mention that we would carry out an audit of all personal data. We would update our privacy notice and review any procedures supporting individuals' rights. We would also identify and document your legal basis for processing personal data under the GDPR. And finally, we would review how we would seek, obtain and record consent.